Welcome to Crash Course Injury Law with Joe Ghabour.
Welcome back to Crash Course Injury Law with Joe Ghabour, founder of GhabourLaw. Joe is a personal injury attorney licensed in New Jersey, New York, and Florida. He helps injured people understand how cases actually move through the legal system and what to expect at each stage. I'm Lisa Mosbey, and today we're talking about what happens during a personal injury lawsuit in New Jersey, from filing through the trial, including how cases develop, where delays happen, and what can ultimately drive resolution. Welcome to the show, Joe.
Thanks so much for having me.
Joe, once a case moves into a lawsuit, what actually changes compared to how a claim is handled before that point?
Well, once a case becomes a lawsuit, the biggest change is that it is no longer just a negotiation file. It's now a court case with formal pleadings, deadlines, discovery rules, and a judge that supervises the entire process. In New Jersey, the complaint and the civil case information statement are filed. The court issues what is known as a track assignment notice, which basically means, the guide to the deadlines or how much time we have for the process. Once the defendant is served, the defendant generally has 35 days after service to answer, and then the case is placed on a discovery track that controls the pace of the case. In a standard personal injury matter, that usually means, and this is of course in New Jersey, it usually means a track 2 assignment, which gives us about 300 days of discovery. And more complex cases like medical malpractice or product liability cases, those are usually put on longer tracks.
And then, Joe, before filing a lawsuit, what needs to be in place for you to feel confident moving forward?
Well, before I file, I want enough proof to do three things responsibly. One, I need to identify the right defendants. I need to explain why they are legally at fault, and I need to show the damages we intend to claim. Practically, that means I want the liability facts, the core medical records and bills, a sense of the treatment course, and any wage loss or other economic losses that we intend to rely on. And of course, all those are the proofs that will help us evaluate and value the case. I also need to be confident that we are filing on time because, again, there is a statute of limitations in every state. In New Jersey, an action must be filed in court within 2 years of the date of the accident, subject, of course, to a few exceptions here and there.
So, Joe, after the complaint is filed, what are the first steps that begin to shape the direction of the case?
The early steps that really shape the case are service of process, the defendant's answer, and the track assignment. New Jersey's complaint package requires us, aside from just filing the complaint, requires us to file what's called a civil case information statement. And once those are filed, the court will issue a track assignment, which is then served with the summons, along with the complaint and the case information system upon the defendant. Thereafter, the defendant generally has 35 days after the service to answer. And it's very, very important to realize that the discovery clock in New Jersey starts to tick, for lack of a better term, on the first answer that is filed or 90 days after the first defendant is served, whichever comes first. So from that point forward, the case starts to move on a real schedule. That early answer stage matters because it tells you what is actually in dispute, what the defenses are, and what the other side is really going to try to pursue.
And you mentioned discovery clock, and I know discovery is a major part of any lawsuit, but what does that process involve in practical terms for both sides?
Discovery is where both sides stop talking in generalities and start putting facts on paper. New Jersey requires us to answer uniform interrogatories for plaintiffs and for defendants in personal injury cases. And interrogatories are just basically questions that you have to be answered in writing. And those questions drill into things like how the accident happened, what injuries are claimed, what treatment was received, and what economic damages are being sought. Further, it also asks about prior claims and conditions that may have existed with the plaintiff. It asks about the witnesses. It asks about the experts, who's going to testify. On top of that, both sides exchange records, including medical records, employment records, or anything of that sort. Basically, anything you intend to rely on in court in trial. You also get to identify photos, um, statements that were given by any party, take depositions of the witnesses that are going to testify in court, whether it's the plaintiff, defendant, or any other witness. And it's also the time to disclose expert reports. So by the end of discovery, each side should know not just the headline of the other person's case, but the proof that's behind it.
And Joe, you mentioned depositions. Depositions can feel so unfamiliar and stressful for most people. What is happening during a deposition, and how do you get someone ready for it?
Okay, so a deposition can be scary. A deposition is a formal question and answer session that's given under oath. So it doesn't matter the location that it's conducted in. The person who is testifying basically has to swear an oath that he or she is going to testify truthfully. And the point of the deposition is to lock down the testimony. So if the plaintiff is going to say something, he can be asked about it later on. So it's also important to have a deposition to learn the facts and details. It's also to preserve any evidence that may be later used in trial. Um, and the New Jersey Standard Civil Jury Charges, which come at the end of a case in trial, specifically recognizes that deposition testimony and interrogatory answers in general can be read into the record. The way I prepare someone for a deposition is not by telling them what to say, because we can't do that, but by making the process familiar. We review the timeline, the records, the photos, any prior statements that may have been given, and the themes that I expect the other side to push on. So the witness walks in understanding the rules of the room and feeling steady instead of blindsided.
And that makes so much sense. How do medical evaluations and expert opinions fit into building and challenging a case?
Medical proof is often what turns an injury case from a story into a case that can actually be tried or settled. In New Jersey, when a plaintiff's physical or mental condition is in question, the defense can notice a physical or mental examination, which basically means they require you to submit to one of their doctors. They usually call that an IME, which is an abbreviation for independent medical examination. But I always tell my clients that there's nothing independent about it. The doctor that is examining them for the defense is working at the behest of the defense. So he's not going to make any favorable recommendations for the plaintiff, unless obviously there's no way around it. Sometimes the injuries are so bad that even defense doctors will have to admit that the injury is there. And if they can make a determination as to what caused the injury, they will. So that's something that they're entitled to. And on the expert side, the rules require us to disclose any experts that we intend to rely on. So the same way that the defendant's attorney is going to send the plaintiff to their doctor, we as plaintiff's attorneys, we also have to provide defense with medical records, any expert reports that whether it's coming from a treating physician or from an independent expert, we have to disclose that as well. Um, there's very, very few things that we cannot disclose, and those are usually under the attorney-client privilege. But anything that we intend to rely on, specifically as it comes to experts, we need to disclose in discovery.
And Joe, at what point in the process do cases usually start moving towards resolution? And what tends to influence whether that happens?
Well, cases start moving towards resolution after all the big proofs are taken. So basically, once the depositions are done, once the medical picture is clearer, once the expert reports are exchanged, that's usually when things start to kick into settlement gear. We also have non binding arbitration in New Jersey, which is basically the court's way of trying to get the matter resolved. And more often than not, if the matter does not resolve in non binding arbitration, the judge will call a settlement conference to see if the matter can be settled short of trial. Very, very simply, nobody really wants to try a case unless they have to. Plaintiffs' attorneys don't, defense attorneys don't, and judges don't, because trials take a lot of time. So there's a lot of effort to try to settle matters. Now, it doesn't mean that all matters will settle. Most matters will, but not all of them. So the ones that really need to be tried, where there is a dispute as to liability, where there's a dispute as to the injuries, then those generally will have to work their way through trial.
And if a case is not resolving and it seems like it's heading toward trial, how does your strategy begin to shift at that stage?
Well, any case that I handle from the very beginning, I work up the case as if though it is going to trial. So if the case is really heading to trial, the strategy shifts from gathering information to presenting a clear and admissible persuasive story. At that point, I'm thinking less about what else I can learn about the case and more about what the jury will actually hear. Which witnesses need to be called, which exhibits matter most, how the experts will explain causation and damages, what facts can be stipulated to, and how the verdict sheet and the jury instructions that the judge will give, all of that factors into the decision. New Jersey's trial management guidelines emphasize trial date certainty once a case reaches the trial calendar. So at that stage, things start moving into gear because it becomes less about getting information and more about actually getting ready for trial. And when the risk of a jury coming either in your favor or against you starts to become real, everybody starts to try to move the matter towards settlement. Again, if it can settle. If it can't settle, then everything is, geared towards making sure the jury understands the liability and the damages in a case.
I'd like to bring this to a close for our audience and wrap up, give them some final guidance. For someone who has never been through a trial before or through this experience at all, what does a trial actually look like from beginning to end? What can they expect?
Well, for someone who's never had a trial before, it could be a scary proposition. A New Jersey civil trial usually feels like a sequence of chapters, like a book. It starts with jury selection, and then it moves on towards opening statements by both plaintiff's attorney and defense counsel. And then you start putting on the plaintiff and the plaintiff's witnesses and the exhibits. And then once the plaintiff is done with her or his case, the defense gets to put on their case if they so choose. And I say that because, again, as the plaintiff, the burden of proof is on the plaintiff to prove his or her case. So if the plaintiff does not meet the burden of proving his or her case, defense really doesn't have to do anything. They can just stand up at the end of plaintiff's case and say, Judge, we want the judgment in our favor because they haven't met their burden. Now, that often doesn't happen, but it could happen. Um, Once plaintiffs are done with their case in chief, then the defense starts with their case. They put on their witnesses and their exhibits and their experts. And once all that is done, we move on towards closing arguments. After closing arguments, the jury is given instructions by the judge on the law. And after that, the jury goes into the jury room to deliberate. And thereafter, they come out with a verdict. It's very important to understand that as plaintiffs in New Jersey, a jury is comprised of 6 jurors or 8 jurors. And to get to 8, both parties have to agree on the 8. If they say no, then it is 6 jurors that have to deliberate. And in order for the plaintiff to be successful, the plaintiff has to have a 6-0 verdict or a 5-1 verdict. So the odds are stacked against the plaintiff, but it's done that way because, again, the plaintiff has the burden of proof. They have to prove with a preponderance of the evidence that this in fact happened, this accident or incident, and that the injuries were sustained as a result of that. So again, it's very stressful. It's a lot of time and effort, both on the judge, on the jurors, and on the plaintiff and the defendant, and on the attorneys who actually are trying the case.
Very well said. Thank you so much for your guidance and insight on how this entire process works.
Thank you.
You're welcome. Folks, that's it for today's episode of Crash Course Injury Law with Joe Ghabour. If you'd like to learn more about your rights after an injury or speak with Joe and his team, visit GhabourLaw.com. Thank you so much for listening, and remember to subscribe, leave a review, and share this episode if you know of someone who needs it. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.